Good afternoon, esteemed members of this international panel of jurists and this honorable and historic tribunal of Black, Brown, and Indigenous people residing in the United States, allies in the world at large. Again, I am Nkechi Taifa, Chief People's Counsel for this proceeding, prosecuting the United States government with violations of international human rights in general and genocide specifically, pursuant to both international as well as domestic U.S. law. And I am honored to officially come back before this auspicious proceeding to deliver the people's closing statement. As you have seen, this was not your ordinary proceeding, and it was not designed to be as such. No, it was not an adversarial proceeding. No defending party appeared. That really is not new, jurists. In many courtrooms in the United States, there may be the purport of impartiality. There may be the assertion of objectivity. There may even be the intent of fairness, but in actuality, there is none. Historically and contemporaneously, systems upon systems upon systems are stacked against a substantial portion of Black, Brown, and Indigenous peoples in the United States, to the extent that disaggregating the voluminous and multifaceted tentacles is too complex to accomplish in any one particular case. So, in this historic proceeding, and at this extraordinary time of racial reckoning, the people have decided to balance the scales of justice and present its analysis unshackled by the colonizers either ignoring our invitations to formally present their opposition, or even when ordered by a court to respond, labeling our legitimate arguments as frivolous. We've had 2 extremely full days of live and pre-recorded and Zoom testimony, some instructional, some heart-wrenching, some both. And jurists, we thank you. We thank you from the very bottom of our hearts for your rapt attention, your dedication to justice, and your search for the truth. We know the proceeding has not been perfect, and we ask that you charge any imperfections to our head and not our hearts. I expressed in my opening statement that as Mamie Till Mobley commanded in 1955, there is a time when we must open up the casket. There is a time when we must right the wrong, and that once again it is time for the world to see and to act. And I stated that that time is now. Now, I could use this closing statement as a time and the traditional opportunity to go step by step through the evidence showing what each piece of testimony over these past 2 days proved, and make the case that the United States is guilty of human rights violations. But I'm not going to do that, because if I did, it would be no different from past major international tribunals post-1951, which have also brought the United States government up on charges. I could have easily called upon the phenomenal students that are part of the Howard University School of Law Thurgood Marshall Center and its movement lawyering clinic to draft a winning closing argument going through each and every point in the indictment. But I did not choose to submit it to them. You see, I wanted to get down to the nitty-gritty, right down to the sticking issue that has kept the issue of genocide from the front burners, right to the issue where expert lawyers, even progressive and revolutionary ones, have tread lightly, either because of fear of being struck down in some instances, or simply because they themselves did not even realize that the Genocide Treaty is in itself a self-executing Treaty. You heard witnesses testify to the definition of genocide as embraced by international law and adopted by the United States. I have no doubt in my mind that we have proved and satisfied the prongs of the definition of genocide: killing members of a group, causing serious bodily or mental harm to members of the group, deliberately inflicting upon the group conditions of life calculated to bring about their physical destruction in whole or in part, taking measures to prevent births within the group, transferring children from one group to the other. I would be remiss, however, if I failed to acknowledge that some feel there is a problem with the requirement of intent, as U.S. courts have historically construed the intent requirement within a general equal protection analysis. In the words of the great Audre Lorde, we simply cannot continue to dismantle the master's house, the colonizer's house, with the colonizer's own tools. We must creatively fashion our own tools that we dare the world to accept. It is obvious that there are few public officials, private individuals, or constitutionally responsible officials who will explicitly state, I have the explicit intent to destroy in whole or in part your racial, ethnic, or religious group. And the United States Supreme Court has yet to abandon its longstanding tradition requiring direct evidence of intent. And as I stated in one of my law review articles, codification or castration, the applicability of the International Convention to eliminate all forms of racial discrimination to the U.S. criminal justice system, published by the Howard Law Journal in 1997, as well as my white paper published by the American Constitution Society for Law and Policy in October 2016, called Racism in the U.S. Criminal Justice System, Institutionalized Genocide. In each of these documents, which I present as part of the record, I've stated that scholars have argued that the current intent standard ignores the way that racism works. And because racial inequality can manifest irrespective of the decision maker's motive, the remedy to that inequality must likewise not be dependent upon provable intentional conduct. I went on to say that the current intent standard ignores the way racism works. And because, again, racial inequality manifests irrespective of the decision maker's motive, the remedy to that inequality must likewise not be dependent upon provable intentional conduct. You see, sophisticated racists, of which the United States has proven itself to be, have learned to code their language and not leave behind a trail of racism. Although cognizable reasons may exist for domestic U.S. courts to decline to extend an equal protection remedy based on cases of provable intentional discrimination, such arguments, no matter how colossal they may appear, should not continue to be allowed as justification to circumscribe justice. Indeed, current analysis must not be allowed to block consideration of creative solutions. This is why appeal to the international sphere is so very critical. As you know, esteemed jurists, international law understands that racism manifests in various forms, allowing intent to be gleaned through actions and impact. For example, the International Convention on the Elimination of All Forms of Racial Discrimination, which the United States has ratified but not made self-executing, allows laws and practices that have an invidious discriminatory impact to be condemned regardless of specific impact, reaching both conscious as well as unconscious forms of racism. Thus, my argument has always been ever since the adoption of CERD, the Convention on the Elimination of All Forms of Racial Discrimination in 1994, that if the intent standard of the Genocide Convention, even with its limitations as ratified by the United States, if the Genocide Convention were to be interpreted in accordance with the intent standard in CERD, the International Race Convention, that the paradigm of genocide against a substantial portion of Black, brown, and indigenous people in the United States, resulting from institutionalized or structural racism, is not just plausible, but actionable. Indeed, there is historical intent in all the categories outlined in the indictment, just as there is unquestionably racially discriminatory impact in each as well. We still charge genocide. Leaving the intent prong aside for a moment, let's go back to that definition of genocide and analyze how the impact of racism could fit that mode. In this vein, I took the liberty to coin the term institutional genocide as a legitimate formulation that illuminates the severity inherent in the international nomenclature, while acknowledging that there may be complications in some people's minds with the U.S. interpretation of intent. What is institutionalized genocide? I submit it is the aggregate impact of discriminatory treatment of an impacted community embedded in laws, policies, and practices of institutions involved in mass incarceration, policing, prosecutions, environmental racism, health disparities, all described in this indictment, though not limited to these categories, which have the effect of destroying in whole or substantial part a racial, ethnic, or religious group. Such destruction manifests through killings, bodily or mental harm, destructive conditions of life, to name a few of the genocidal definitional factors. This destruction may or may not be the result of conscious choice or intentional deliberate decision-making. Indeed, let's not forget the fact that under the definition of genocide, actual intent to commit genocide is not the only actionable act. It also includes conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, and complicity in its commission. Who's going to open up those caskets? The United States must not be beyond scrutiny. It must meet its commitments. It must review its own record, and it must be open to criticism and rectify injustices. Remedies, we call upon this body to rule that the United States must fully embrace the human rights conventions that the United States is a party to, and eliminate limitations to their use in U.S. courts. These include, but not limited to, the Convention on Elimination of All Forms of Racial Discrimination, the Convention Against Torture, the Convention on Civil and Political Rights, the Office of the High Commissioner's Basic Principles on the Use of Force and Firearms by Law Enforcement Officials, and for this particular tribunal at the top of the list, the Convention on the Prevention and Punishment of the Crime of Genocide. Under international law, as well as under Title 18 U.S. Code. In addition, there is unfinished business since the Civil Rights era. And that unfinished business is the plight of the political prisoners and prisoners of war who are still languishing in prisons as a result of that era's illegal actions against Black, brown, and indigenous people. That unfinished business must be their freedom. Many of their cases are enshrined in the appendix that is part of the documentary evidence for you. We're not now talking about transfer to a third world non-imperialistic country, as was one of the original demands from the 1971 Attica Prison Rebellion. We're not now talking about a prisoner exchange, as was a demand by Amari Abubakar Obadeli and the Republic of New Africa. We're not even necessarily calling for recognition pursuant to the Geneva Conventions of 1949 and its protocols dealing with the status and treatment of prisoners of war. Today, it's real simple. The demand is for clemency, presidential or gubernatorial clemency for our political prisoners and prisoners of war. Pardons for those who have been released or in exile. Let's not forget a demand for posthumous pardons for those who have already passed. There are political prisoners, COINTELPRO era, who are elderly, those vulnerable to COVID-19 or in recovery from it, those who were sentenced before the federal sentencing guidelines went into effect and are still subject to non-functional parole boards. Egregiously, not one governmental official responsible for counterintelligence program, COINTELPRO, ever served a single day in prison for their crimes. Yet, there are still political prisoners languishing behind bars, those still subject to parole restrictions or in exile. You see, jurors, in this vein, the United States government does not even need to invent any new wheels. There are already precedents with other groups of people in this country that has already been set. The Civil Liberties Act of 1988, which granted reparations to Japanese Americans for their unjust incarceration during World War II, explicitly included a pardon for all those who resisted detention camp internment. What about a pardon for all those who resisted the war of COINTELPRO waged by the U.S. government against a substantial part of Black, brown, and indigenous people, and who remain in prison today as a result? Commutation of sentence for those still incarcerated, calling out just some of their names: Imam Jamil Al-Amin, Suniyata Akoli, Mutulu Shakur, Veronta Bowers, Mumia Abu Jamal, Russell Maroon Schultz, the Virgin Islands Three, Fred Burton, Joseph Bowen, Leonard Peltier, Rochelle McGee. If I missed any, just call out any of those names of our political prisoners who are still languishing. If I missed any name that comes to your mind, just call it out so the jurors can hear. Keep it going. Thank you, absolutely. And also a pardon for those in exile: Assata Shakur, Pete O'Neill. If I've missed any, that you can say that they're in exile, but call out those names. Pardons for those who have been released but might still be subject to restrictions: Jaleel Muntakim, Herman Bell, Ramona Africa, the Move family, Daruba Ben Wahad, Jihad Abdulmumit, Tariq James Haskins. If you know of any others who are on parole that should receive a pardon as part of a remedy with respect to this tribunal, make sure we know those names. And then finally, a posthumous pardon for those who are in the ancestral realm. The Honorable Marcus Garvey never received a pardon for that unjust incarceration. President Imari Obadeli, Albert Noah Washington, Safia Bukai, Geronimo G. Jagger, Atiba Sana, the Move members who are no longer with us. If there's anyone else that you would like to share, make sure we know those names as well. Uwezi Balagoon, absolutely. Imtayari Shabaka Sunyada, and the list goes on. It is clear, as I come to a close, that the horror of racism, overt as well as institutional, it is clear that this horror has not been repugnant enough for the fashioning of structural solutions to abate the problems. It is our intent and our hope that this tribunal's application of the intensified nomenclature of genocide will shock the conscience of the public to intensify actions to remedy the problem. Perhaps the stark correlation by this international tribunal between the internationally accepted definition of genocide and the juxtaposition of that definition against the impact of racism in the United States against Black, brown, and indigenous peoples, perhaps, just perhaps, the use of the term genocide will spark needed revolutionary change in policies and practices in this country. So in conclusion, our ancestors on this sacred space that we are now standing in what was once the Audubon Ballroom, where our Black shining prince lay prone on the ground, our ancestors would turn over in their graves if they felt we were complacent with the status quo and failed to pick up the baton from the still pending 70-year-old 1951 petition, we charge genocide. Jurists, we feel that we have shown that both the testimonies you have heard as part of this tribunal, as well as the documentary evidence, we feel that we have shown unequivocally that the United States violates not only elemental principles enshrined in the US Constitution, but basic human rights outlined in a myriad of international instruments in general, including the Convention on the Prevention and the Punishment of the Crime of Genocide, specifically. Jurists, the casket is open. As Chief People's Attorney prosecuting this case for this tribunal, I humbly ask, in the memory of ancestor Brother George Jackson, who was assassinated in 1971, and in the immortal words of exiled Assata Shakur, that Black, brown, and indigenous peoples in the United States will carry on the tradition of resistance, and pray that this body of esteemed, internationally acclaimed jurists will find the United States guilty of the renewed charge of genocide. We still charge genocide. Ashe, ashe, ashe-o. Thank you very much. I would like to thank all of the lawyers and the student attorneys who participated in the direction of witnesses today, all the witnesses who participated, the official legal observers who have been providing very helpful observations. And I want to bring up at this time to close us up my chief clerk, Brother Jihad Abdulmumit, who is part of the coordinating committee of the Spirit of Mandela, who is the entity coordinating this entire event, who will close us out, Brother Jihad Abdulmumit.
Acknowledging our dear jurists, each and every one of you, with a prayer. Very befitting to invoke the blessings and graces of the Most High. أعوذ بالله من الشيطان الرجيم. نعوذ بالله من الشيطان الرجيم. I seek, you seek, referencing Allah, from all those people influences that causes us to be disunited. It causes us to never receive any resolution on the issues that impact and cause our demise. We seek refuge in Allah, that we can move forward beyond these obstacles that causes disunity in the lack of resolution. Alhamdulillah, all praise be to Allah, the Most High. And however you may worship the Creator in your own language and in your own words, we pray that Allah, subhanahu wa ta'ala, the glorious, the Most High, grant each and every one of us the peace within our bosom, the love for one another, and the determination, as our comrade Jalil Muttaqin has always said, and it's a very empowering statement, for our jurors, and for ourselves, that we are our own liberators. Assalamu alaikum. I'm not going to ask everybody to chill while we let the jurors go to the room, and if they come out, you know, we can interact with them then. I just don't want them to be things to go over the top. Jurors, thank you so very much. We'll give you a minute before we